On behalf of Freeze, I'd like to welcome you to the first in a series of our sector-focused webinars. This one's on shaping the future international workforce for the higher education sector. Joining me on our panel of experts today are Emma Brooksbank, who's a partner in the business immigration team at Freeze, and Jaspal partner in the taxation team at Freeze. So the format of today's session will be this. Emma, Jaspal and I will spend just a few moments setting out some of the key immigration, tax and employment law considerations of an international workforce, which may result in your staff working at all ends of the globe. And we'll then open up the session for questions and a wider discussion. So please do submit questions. We've had some already, but keep them coming in. There's a Q&A function on Zoom at the bottom of your screen. We'll endeavour to answer all your questions today, but if there are any we can't get to, we will come back to you independently over the next few days. So I'm going to kick off just talking about a few of the employment aspects of shaping the future international workforce. And these are really questions and considerations rather than any answers at this stage. And there's probably 3 points that I think are, well, more than 3, but there are 3 key ones that jump out to me. The first is around jurisdiction. So what employment legislation applies to staff who live or work overseas? What's the framework of any dispute that may occur? You need to think about that. Not least because understanding what law applies will probably reduce the risk of any dispute in the future as well. The second is around the contractual provisions. If you are engaging staff overseas, will that be on your standard UK terms? And how will that arrangement work in terms of where they live and where they work? Will it be a temporary arrangement? Is it a permanent arrangement? And what sort of flexibility will be built into that arrangement? Will you have the right to call them back to the workplace or work in the UK from time to time? I think in terms of these kind of arrangements, it's a good idea to think about the particular circumstances of an individual employee and draft terms that match those particular circumstances. And the last point is the right to work overseas remotely. If you're talking about a UK member of staff or someone that's engaged in the UK and they want to relocate overseas, who decides? How do they decide? What process will be in place for that to make sure that the employer, you, treat everyone consistently and fairly and take into account any potential risk of discrimination? There's many more aspects to the considerations, and I know that some of the Q&A questions deal with those, and I'll come on to those shortly, but I'll hand over to Jaspal to deal with some of the tax considerations.
Good morning, everyone. As Chris has said, I'm going to look at some of the tax issues that arise as a result of employees working overseas, and in particular the effect on tax residents, tax filing obligations and permanent establishment risk from both the perspective of the employer and the employee, but mainly from the perspective of the employer. Some of the issues are quite complicated, so what follows is very much a gloss on some of the issues. As an initial observation, a number of you may have had to look at some of these issues where you have previously asked an employee to work overseas, or possibly in recent months where employees have been stranded overseas as a result of lockdown. The focus of this talk is what happens where, post the current COVID-19 crisis, employees choose, with their employer's blessing, to work overseas. There is, in my view, likely to be a difference, or at least a shift in approach. Where an employer is asking employees to work overseas, it may be minded to think about things like tax equalisation policies, i.e. looking to ensure that the employee is not disadvantaged from a tax perspective as a result of the move, whether in terms of rates of tax or timing of tax payments, and other tax policies such as assisting employees with tax compliance. In a scenario where an employer is looking to accommodate an employee's preference to live and work overseas, the emphasis may be different. And indeed, the employer is likely to be looking at the matter from a protective position in relation to what tax compliance obligations might be created for it as a result of the employee moving overseas, in both the UK and the new overseas jurisdiction. So what are the sorts of tax issues that need to be borne in mind? In a sense, they split into 2 categories: those that relate to the employee and those that relate to the employer. Looking quickly from the perspective of the employee first, if an individual chooses to move countries permanently, they are likely to become tax resident in their country of arrival, particularly if they expect to spend more than 183 days in their new jurisdiction in any relevant tax year. They may also continue to be resident in the UK for a while, particularly if they continue to spend some time in the UK or have other ties to the UK. In practice, this means that they are likely to be subject to a new set of tax rules in their new jurisdiction with the associated tax filing and tax payment obligations, and may continue to have tax filing and payment obligations in their home jurisdiction for possibly months or years. This will obviously need to be thought through carefully. Generally, where someone leaves, for example, the UK to go to another jurisdiction with which the UK has a double tax treaty, and noting that the UK has double tax treaties with more than 130 countries, the treaty will set out which jurisdiction has primary taxing rights, i.e. the jurisdiction of treaty residents, which jurisdiction has taxing rights over particular sources of income and gains, and whether and which jurisdiction should give credit for tax paid in the other jurisdiction so that there is no double taxation. Even where there is a treaty that applies, the procedural and tax filing issues may be complicated, and the employee should take tax advice from both the country of departure and the country of arrival. To compound the complexity, consideration should be given to whether the employee needs to charge VAT or equivalent taxes on the payments to it in the local jurisdiction, and the employee may also find that in due course they become subject to the new jurisdiction's rules on inheritance and estate taxes. So that's the employee. What about from the employer's perspective? Here the issues are both simpler and more complicated. They are simpler in the sense that generally, with a few big pinches of salt, if an employee permanently ceases to be resident and performing their duties in the UK, an employer will generally no longer be required to operate UK PAYE, though this is not automatic and the employer does need to make the appropriate filings with HMRC. There may, however, continue to be UK PAYE obligations for the employer if the employee will continue to physically perform duties in the UK, in which case an apportionment of earnings between UK duties and non-UK duties may be necessary. The issues are more complex because there are two big question marks in relation to taxes that the employer may be subject to in the employee's new or adopted jurisdiction. The first, and most obviously, is employer payroll taxes in the new jurisdiction. What is the consequence for the employer of having an employee in the relevant jurisdiction? Does the new jurisdiction require the employer to register for, make local tax filings and operate local payroll taxes, even if the employer has no other presence in the new jurisdiction? This is a real possibility and should be confirmed with tax counsel in the local jurisdiction. It may be that the employer can appoint a payroll agent in the local jurisdiction to do so. The second concern, and possibly of greater concern, is whether the mere fact of the employee's presence in the new jurisdiction could create a permanent establishment for the employer, so that some of its worldwide profits and gains are potentially subject to tax in the new jurisdiction. And here the question will really turn on what the employee does. Are their functions central to fee generation for the employer, or are they merely preparatory and auxiliary to the activities of the employer? Should the employer consider using a local entity, such as a subsidiary or other group company, to engage the employee in the new jurisdiction? Should the employer consider abandoning entirely the relationship of employer and employee and turn the relationship into an arm's length consultancy, with the employee setting up as an independent entity in the local jurisdiction? These again will be matters that need some careful thought and consideration, including advice from local counsel. And with that, I will hand over to Emma to look at some of the immigration considerations.
Brilliant, thank you, Jaspal. Yes, so I'll be looking really at the impact on immigration status of having employees working overseas. Now, working overseas isn't unusual at all for the higher education sector, but we've seen that the lockdown and the COVID crisis is perhaps acting as an accelerant to employees opting to work overseas, so opting potentially to want to work remotely and for that work to be from their home country. Now, for the time being, I am basing what I say on the idea that the employee is in home country rather than a third country. And I think from what we've heard from Christopher and Jaspal, you know, there is a desire within the sector to be able to offer that flexibility, but that it's all about understanding and managing the risks of having these arrangements moving forward and potentially on a long-term basis. So from the employer's point of view, and from an immigration perspective, the key really will be to understand whether the employer has sufficient control and visibility over the employee if they're working overseas. And this is particularly pertinent where you have a sponsored employee. So the question really is, can you, as an employer, continue to satisfy your sponsor duties? Can you ensure that you have sufficient visibility to do that? Now, from the employee's point of view, the big factor that they need to bear in mind when it comes to working overseas is the impact of absence on their visa status in the UK. So as a rule of thumb, we're looking at no more than 180 days absence in any year. That comes into play at the point at which an employee is thinking about wanting to secure indefinite leave to remain. So here we're thinking about employees with visas who will complete a qualifying period and wish to secure indefinite leave to remain. Now, at that point, they're going to be looking back at their qualifying period, and they shouldn't have more than 180 days absence. But that is calculated on a rolling basis. So in any 12-month period, unless we have a period of leave which commenced before the 11th of January 2018, in which case we look at 12-month blocks counted back from the date of the indefinite leave to remain application. So there's more flexibility when we're looking at older periods of leave, or perhaps longer periods of leave where you might have a 5-year period of leave granted pre-2018. In those cases, it is possible to sort of manipulate absences to ensure that they fall into one or other 12-month block. Now, in terms of absences, there are some exceptions, and importantly for the university sector, if we're absent for research purposes and we're in a PhD role and sponsored, then those research absences will not count towards the 180 days. Absences apply to dependents, but they don't apply to children. Now, it is important for an employee to bear in mind the fact that allowable absences, so these 180 days, should be consistent with the purpose for which permission was originally granted. And so really the way to interpret that is, if they have a sponsored worker visa, then their permission has been granted for them to undertake that role in the UK. And so really their absence should be consistent with the role that they are sponsored to undertake, or it should be for a serious or compelling reason. It is also possible to exempt some absences for a serious or compelling reason. Now, in terms of absences, people also just need to bear in mind that we have this 180-day threshold, but often once somebody's secured indefinite leave to remain, they want to be looking then towards naturalisation. So often people then want to become a British citizen, and the absence threshold for British citizens is different. So as a rule of thumb, they're looking at a 90-day per year absence threshold. There is quite a lot of flexibility within that, but when they're thinking about a proposal to work from overseas, they do need to factor in the impact on their visa and the impact on their future citizenship rights. Now, I'm just going to mention curtailment and expiry. Now, of course, if they're visa holders, they do need to be alert to the fact that if for any reason their visa was curtailed, if they were in the UK, they'd have a curtailment period, which gives them a bit of time to resolve whatever the issue may be, or to move employers if they need to, or secure new visa status, and they'd have 60 days to do that. If they're out of the UK, then curtailment is instant, so there's no grace period, so they lose the benefit of a curtailment grace period. And the other thing that, of course, they need to be alert to is that visa expiry date. If their visa expires and they're overseas, then they won't have an automatic right to return to the United Kingdom. So they may well then need to be applying for entry clearance, which could be straightforward. But if we're thinking about Tier 2 visa holders, if they've previously held Tier 2 leave in the United Kingdom, which is not an unusual situation to be in at all within the higher education sector, and their leave expires while they're overseas, then they're going to be caught by the cooling off period and they wouldn't be able to return for 12 months. So that's something that they just need to be acutely aware of, the date of the expiry of their visa. So that's everything that I'm going to cover for now, but I know that we've had quite a few questions coming in. So I'm going to hand back to Christopher, who'll divvy up those questions between us.
Thanks, Emma. I think the first one's probably mainly for you, but I will chip in if we can. If someone's visa has been accepted but is waiting their BRP, which has been delayed, which I know many are at the moment, is there any different advice about travelling? We have some members of staff that may need to travel for work, but also what if they need to travel in an emergency? My understanding is that they should not. However, with delays, this is becoming increasingly impractical.
Yeah, so it's a really difficult situation. I presume here we're talking about a situation where the person's in the UK and they've been granted the visa and they're waiting for their BRP in the UK rather than having a person outside the UK. The general advice, for good reason, is not to travel until you have your BRP in place. So the advice in this situation would really be contingent upon several factors. So how much of an emergency is it? If it's work related, can it really not be pushed back? Bear in mind the fact that even though things have been locked down, and we do have a backlog, that is now starting to be relieved, and so centres are opening and processing is starting to happen. So we're not looking at an indefinite period of delay, we're looking at delay which is shortening all the time. So would it be possible for that delay, that travel, to be pushed back by a couple of weeks, by which time, if a visa's been accepted, you should expect to be able to secure a BRP. If it really isn't possible, so family emergency, some sort of emergency, or a conference that has hundreds of delegates that really can't be pushed back and you're the keynote speaker, then the person would have to travel. They have been granted leave, but they just don't have their BRP to demonstrate that they have been granted leave. They would be in a less risky position if they had an alternative route to return to the UK. So for instance, if they were a non-visa national, but if they did travel, having been granted leave, if they really had to, they should be able to persuade, I think, an immigration officer to permit them to enter, and by which point you'd hope that their BRP would be ready and they'd then be able to collect it when they return to the UK. So general advice is avoid if you can. If you really can't, do it, and it should be okay, but you can't absolutely guarantee that.
Great. Thank you. So, Jaspal, this might be one more for you. Will the employer be liable for a failure of the employee to comply with its personal tax obligations in the new jurisdiction?
Well, this is an interesting question and somewhat difficult to answer in the abstract. It really depends on the tax rules of the local jurisdiction. Where an employer has no other presence in the new jurisdiction, there may be an assumption, rightly or wrongly, that personal tax compliance is a matter for the employee. The tax rules in some countries, particularly some developed countries, can be unexpected. Ideally, the employer would take advice in the local jurisdiction. As a practical matter, a tax authority is unlikely to want to pursue an employer with no assets or in the jurisdiction, and generally the UK courts have sought to avoid enforcing the tax rules of foreign countries. Stepping back from whether there is a strict or secondary liability for the employer, an employer should also have regard to reputational practical concerns. If an employee has not complied with its local obligations, that may strictly be a matter for the employee alone. But if you have employees who are subject to demanding tax audits in their new jurisdiction and calls for unpaid taxes, this may have an impact on the employee's ability to perform their job effectively. There may also be an unwelcome surprise when the employee is pursued for taxes in both jurisdictions. So, notwithstanding my comment at the beginning of this sort of seminar that the focus or shift may be different when an employee's chosen to move overseas, you still don't escape those sort of real practical and reputational issues of having someone working in a different jurisdiction to their home jurisdiction.
Thanks, Jaspal. This might be a bit of all of us. I think the person that's asked this question is not actually in the session today, but they've probably worked out that we're going to send them the recording afterwards. So I'll send them what minute we answer their question, and they can flick to that and ignore the rest of it. What are the restrictions on employing a lecturer overseas to remotely deliver What are the restrictions on employing a lecturer overseas to remotely deliver teaching in the UK? Anything on your side, Emma?
Yeah, so no, as in there are no restrictions if they're delivering all of their work remotely, so from another country, then I'm redundant. No immigration requirements here.
Okay, and I think the same would apply on the employment law side, that there are no restrictions on that, but that there are plenty of things to think about if you're going to do it. And I've got a similar question about what happens if there's an employment dispute when someone's employed overseas. So I'll give the difficulties rather than restrictions, or certainly the considerations about some of that. So the things you'd think about in this situation is, and I mentioned at the start of the talk today, what's the territorial jurisdiction? What law applies in these kind of cases? And there isn't a universal test to work out whether UK employment law applies or not, and it very much depends on the facts. And in this case, you've got someone who may be a foreign national and working overseas. So there are a few things to think about, but certainly the biggest consideration is whether they've got a strong enough connection to Great Britain for British law to apply. And that means that the employment tribunals in the UK will deal with any potential dispute. There are a number of things to think about when you're considering this, and I'll talk through some of those considerations because it might be useful to think about on a case-by-case basis. So in this case, they're employed by a registered British institution, although that in itself isn't enough to make UK employment law apply. There's a question about where the work is done. That would be considered by an employment tribunal. And although here the work's being done abroad, it is being done for the benefit of a UK and a British institution operation. And assuming in this case, if the employee is being managed operationally and in terms of HR as well from the Great Britain, then you're seeing a stronger connection with Great Britain than perhaps you would otherwise. It may depend what pension scheme they're in. If they're in the USS, which is connected to Great Britain as well, it may be a relevant factor. And certainly what the parties talk about at the time they're engaged would make a difference. So if your employment contract says governed by the laws of England and Wales, and you agree with the employee, that's the law that will apply as well, it may make a difference. One of the things that the judges do consider in the employment tribunal when someone's applying for jurisdiction in the UK is where they get paid and what currency they're paid in, and whether they pay tax and whether they pay national insurance contributions as well. So I think in this particular case, I think you can assume that they're probably sufficiently connected to Great Britain to bring claims in Great Britain in the employment tribunals in England and Wales. One of the things that Jaspal mentioned in his talk at the top is that they may also have rights in their own jurisdiction, and that would apply in terms of employment law as well. So they may have employment rights wherever they live, and it's well worth taking advice in relation to those additional employment rights they may have. That's not something I could advise on, but we do have an international network at Free. So if you need advice about local jurisdictions, then please let us know. And I suppose the other point, which is not relevant, I should probably mention, is that their nationality itself is not relevant. So it doesn't matter whether they are a Great British citizen or something else in the home country. That's not relevant to whether UK law applies. Jaspal, anything from you on that side?
Well, I think we've probably dealt with some of the main issues. I mean, I suspect, we can look at permanent establishment. I think there's a question around us in a minute. But I mean, I suspect if you've got a lecturer who's simply sort of dialing in to give a few sort of Zoom or Teams lectures, that's probably not going to be enough to amount to a permanent establishment. I mean, I suppose there'll be a sort of a granular analysis as to whether this person is an employee or maybe they're just engaged on some sort of sporadic or other basis, in which case there may be no sort of employer payroll tax obligations in the local jurisdiction. But I think, as you say, all these things need to be considered in the round. Likewise, where someone is a national of the jurisdiction that they've moved to, that may have an effect in terms of the treaty interpretation, because it may be another factor that links them to the jurisdiction that they've moved to. So it may have an effect for the purposes of any treaty tiebreaker. But otherwise, I'm not sure I have anything further to add.
Thank you. One question just in is probably more for me. Does TUPE apply to employees who are employed by a UK company to work in an overseas office? Probably, yeah. So TUPE applies to anybody that's engaged in the UK prior to the transfer to any foreign jurisdiction, regardless of what country it's in. So if you're talking about someone employed by a British institution that's being transferred outside of the jurisdiction to a different legal entity, TUPE is likely to apply. It may not if you're simply posting someone overseas. If they remain employed by the same UK legal entity, it's just a secondment or a change to their terms, and TUPE wouldn't apply to that. So it's only if they get transferred to a different legal entity. Emma, one for you, gets addressed to you. Emma, with ILR, would you anticipate that the Home Office will agree for COVID-19 absences to fall outside the 180-day threshold? Would you anticipate that this would fall within the humanitarian or environmental crisis exception, or would you expect specific exceptions to be added?
Yes, I would expect that we'll see a specific exception added, but we don't have that at the moment. And so without that, it is a risky operation, I think, really for somebody to be overseas at the moment and to fully anticipate that they may be able to rely on excess absences being accepted, being exempt, essentially. I think a lot will depend on whether they've opted to stay outside the UK or whether it has been impossible for them to return to the UK. So of course, when we had significant travel bans, there was an impossibility of return. Now we're seeing great possibility of travel, but for important family reasons, people are wanting to remain overseas with their family members and perhaps not wanting to come back to the UK at this stage. I do think that we will see a specific exemption carved in, but until we have it and until we know the exact terms of that exemption, I would probably be advising against people anticipating that they might be able to rely on an exemption. We'd like to see it, and I don't think that the rules and the guidance as it is currently drafted gives us a strong enough basis for there to be an exemption in place already.
Thank you. Jaspal, one for you. Can you talk more about sorry.
I was going to say on that, actually, I mean, there are similar considerations from a tax perspective. I mean, I was focusing on sort of post-COVID-19, but there are interesting questions around tax residence where someone has been forced to be in a jurisdiction because of lockdown. I mean, different jurisdictions have taken different approaches. Some have been more open and some have been less open. I mean, the UK has given some guidance around UK residents, but that there are still gaps in the guidance. So very broadly, you would hope that if someone has been forced to be overseas as a result of lockdown, that wouldn't change their tax residence. but again, that shouldn't be assumed. And that is an interesting question that we've been looking at quite a lot in recent months. And it really means working with local advisors to understand what sort of approach their jurisdiction has taken.
Okay. Oh, well, in that case, I might also weigh in on some employment aspects of that as well, then, if you're all going to have a chat about this bit, in terms of where people were stranded because of lockdown. Because there are the arguments of advice on this, where people have been asked to work overseas and they're then being stranded there in lockdown. The question is whether they get paid, how they get paid. And the answer is, generally speaking, if you've required someone to be abroad and work overseas and they get locked down, then even if they can't continue to work because of lockdown, they can't work remotely, there would be an obligation to pay them because you've asked them to be there. And you would need to consider about what you do with their expenses as well, because there's probably going to be additional expenses for further accommodation. The answer is probably different though if they choose to go overseas and they get locked down, because then it's arguably, or they're not really willing and able to work. So whether you pay them or not is slightly more complex, because if they're on lockdown because they've got a self-isolating or some kind of quarantine because they've been exposed, they may well be entitled to sick pay even though they're overseas. But if it's simply because of travel restrictions, then it may well be the case that they're not entitled to pay. So yeah, I get that, which is good. So Jaspal, is she next? Can you talk more about permanent establishment risk? What does it mean?
Okay, so a person carrying on a trading activity will generally be taxed in that jurisdiction if they are tax resident there. So in the case of a company or other body corporate, this will usually mean the place where it is incorporated or the place where its board meets. But a person can also be subject to tax in a jurisdiction in which it has its place of business or permanent establishment. Essentially, the test is whether that person conducts a trade through that local permanent establishment. Notwithstanding, an employer may not have a place of business in the new jurisdiction. If an employee is working from an office, including a home office, that may be enough to amount to a place of business for the employer. The question is really, what does the employee do in the local jurisdiction? Does what they do generate income for the employer? Usually what you're looking for is the end relationship with the employer's clients and whether it generates income or books profits for the employer. If sales are not booked in the new jurisdiction, that might be expected to be okay. So it probably isn't enough having, an expert or lecturer in the new jurisdiction being a draw for students, but given the risk of becoming subject to tax in the local jurisdiction, as part of that wider employment and immigration review in the local jurisdiction, I think it is worth confirming whether, having regard to the local laws in the new jurisdiction, this is a risk in the relevant case. I mean, the issue may be more acute, for example, if the staff you've sent overseas are concerned in attracting new students and signing them up to courses with the university. I mean, clearly there, what they're doing is some sort of, profit generating activity. So I think those are the sorts of issues you'd be thinking about, Chris.
Thanks, Jaspal. Emma, is there an argument to support the position that we should stop sponsoring overseas nationals on visas and have our international workforce working from overseas?
It's certainly an attractive proposition, isn't it? No more sponsorship, no more sponsor duties. I'm sure from HR's point of view or from the compliance officer's point of view, that would be appealing. This goes back, I think, to the question of whether the role can be completed lawfully and effectively when overseas. So some roles will be suited, but others may only be suited to overseas work either on a short-term basis or an emergency basis, or not at all. On a practical basis, so probably I think Christopher and Jaspal will be able to wade in here in terms of thinking about the practicalities of whether roles can be completed overseas on a practical basis. From an immigration point, yes, you carry less risk by not sponsoring migrants on visas in the UK, and if they were needing to travel to the UK to engage in meetings or share their research, for example, then they would be able to do that, and there's various mechanisms within the rules which would enable them to do that on a reasonably straightforward basis. I guess the final point from me on this is that we have to recognise that as attractive as it is to work in a university, the job itself is not always the sole reason for people wanting to undertake a role in the UK, and people are looking for a life in the UK. They're looking for a life in the UK with their dependents, and that all comes as part and parcel, and that is what makes the UK and the UK higher education sector an attractive destination. So I imagine that there will be a reasonably substantial section of international employees who, even if policy was to prefer people to work from home country, would still, I think, opt and wish actually to have a visa which would enable them to spend at least part of their working life in the United Kingdom. I don't know whether there's anything, Christopher or Jaspal, that you want to add in terms of this sort of hypothetical proposition of, do we just have everybody working from their home country who can?
On the employment side, and I'm gratified to hear that they can go and come to the UK when appropriate to share research, because the employment relationship really can be contracted to be whatever you want, and if it's to work from home, but we can require you to attend the workplace, or you should when reasonably required to do so, and I think you can deal with the practicalities. There are real issues for employers though in terms of allowing complete remote working, and I don't think we've seen some impact of that yet, in terms of it requires a different skills as a manager entirely to manage remotely. And there are things that happen, this is not really employment law, but there are things that happen in the workplace in terms of those casual interactions where inspiration comes from that you just lose. And I don't mean the gossip about Love Island, I mean the wider talk that you can take ideas from. So I think that there are issues with that, and there'll be issues about how you manage performance and how you engage properly. But from an employment law point of view, I don't think there's anything else to add. I think for you, Jaspal?
Yeah, I mean, I think, the question is how much of a compliance burden do you face if you, I mean, it might be easy if you end up with sort of, a third of your workforce working from, one particular EU member state. I mean, just as an example, I mean, it may be worth, doing that sort of investment of time and effort to work out what obligations you have in that jurisdiction. And of course, the more people you have in a jurisdiction, that might be indicative of you having some sort of presence or place of business in the relevant place. I mean, what do you do if you've only got one person in, that jurisdiction? You've got people in sort of, 50 or 100 countries. I mean, I think, I think there are sort of interesting issues around, what are your obligations in relation to the sort of, taxes that would need to be thought about.
That's an interesting point on the potential discrimination side, because if there seem to be particular areas we've got large numbers, so we know how to operate in that area, or easier jurisdictions, and that's the area we concentrate on, and we're talking about people living in their home countries, then it may mean that you don't employ people that happen to be nationality of a different country. That could be indirectly discriminatory. So it creates different and interesting areas to consider there as well.
Yeah, I mean, I think it is interesting, and I think, I mean, where I've been looking at this for clients, there's there are usually a few identifiable individuals that this applies to, and there's the desire to seek to accommodate the arrangements. But I mean, it could become much more difficult if you have sort of, significant, percentage of your workforce seeking to work overseas. Because as we've said, this can create all sorts of consequences for the employer in those jurisdictions, and indeed issues for the employee, which the employee may not be well placed to consider and deal with. So, I mean, there is a reason why historically people have been employed in the jurisdictions that they work in. And I suppose, that's not to say it can't be done, but they are things that will need to be thought through carefully and in a considered way.
Jaspal,
Just bringing up your point, would there be grounds to be able to say, well, actually there's a threshold and we wouldn't want people working from a certain country because we can't manage the risks in that country? Or would, if you had a policy, would it have to, from an employment law perspective, be applied consistently to all employees?
we can objectively justify indirect discrimination. So there may be that we can say that there's a legitimate aim and a proportionate means of achieving that aim. So it may be you can justify it. But I think it would take a lot of thought. Just because it's more difficult would not be a reason to discriminate, because it's nearly always easier to discriminate than not to. So that's a question I think we'd have to look at a particular jurisdiction on a particular case-by-case basis. Jaspal, can you discuss the use of payroll agents or umbrella type companies for employing foreign nationals in their home country to Zoom lectures to UK students?
Oh, yeah, it is a difficult question. I mean, I think the starting point with all of these things is to try and work out, you know, what is the relationship between the engaging institution and the individual providing those services. Is it, I mean, you know, and this is sort of, you know, painting a picture, you know, how strong or weak is the relationship? I mean, if you've got a visiting lecturer who maybe does, you know, 1 or 2 lectures a year, I mean, the considerations are probably going to be different if you've got, you know, a sort of a permanent member of staff who works sort of 5 days a week, 9 till 5 for that institution. I mean, you know, local payroll agents maybe, as I said in my talk earlier, maybe an opportunity to ensure that if the employer has any payroll obligations in the local jurisdiction, or even if it doesn't, but because it's considered expedient to assist the employee in its own tax compliance. I mean, that might be a solution. I mean, it doesn't necessarily deal with the permanent establishment risk. I mean, as I said, one thing that you might look at doing is using some sort of you know, personal service company for the lecturer to provide their services to the higher education institution in the UK. Now, you know, that might assist with the permanent establishment sort of risk. But as I say, I think these things need to be considered in the round. I think they are quite difficult issues, and I think you know, just assuming that by appointing a local payroll agent or, you know, getting the person to work through an umbrella company will, you know, necessarily make the problem go away, is difficult. And actually, the question normally around sort of umbrella companies and payroll agents is more concerned where you've got a UK person who is subject to, you know, UK taxes. Now, you know, there's a question mark as to whether a UK or a person who's no longer resident of the UK and not performing any duties in the UK would have any UK tax obligations. I mean, I think that's where you'd probably start first, actually. But it is a difficult question.
Thank you. This might be one more for me. So the question is, it may be easier for some staff than others to work remotely. Is it acceptable to have different arrangements for different departments? So from my point of view, it's a possibility. And it is, I said at the start, it's really important to be clear about how you decide who can work remotely or globally. This is all about, I think this is a question more aimed at UK staff that are relocating. I'm assuming that anyway. So it's good to have good policies and procedures in place to help with that that decision-making process for transparency for both the employer and the employee. But I think my view would be it's far better to have one policy and one procedure for an entire organisation, even if that means that inevitably certain groups are less likely to obtain approval by going through that process, because I think it's really risky to assume that certain groups or certain areas can't work remotely or globally compared to others. You may have a particular area that is more likely to be populated by women, for example, because of historically that's an area that they are more likely to be engaged in, and that could be indirect sex discrimination. So I would probably have a consistent process throughout. Although I am seeing different organisations at the moment have different types of remote working, and perhaps this is slightly beyond what we're talking about today in terms of a global workforce, but certainly I'm seeing a policy for agile working compared to a policy for flexible working. And agile working policies are more around you get to choose where you spend your morning if you're doing a particular thing, whereas flexible working is more about making a permanent change and a process for a permanent change, for example, live and work abroad going forward. Nothing from anyone else on that? Great. Okay, so we'll take one more question, I think, and then we'll start to wrap up. What have we got? It's the last one. I better choose a good one. Emma, what's the position for European employees who wish to spend time abroad?
Okay, so a good lawyer answer, it depends. It depends on their current status. So the key things that they will need to be considering and will just need to bear in mind, if the university is happy for them to work abroad, the things the employee is going to need to think about. Again, it's all about absences. So do they have indefinite leave to remain? If they do, how was it granted? If it's granted through the EU settlement scheme, they've got 5 years worth of flexibility. They could be absent for 5 years without damaging that status. If it wasn't through the settlement scheme, they have 2 years. They can be absent for 2 years without damaging their status. If, on the other hand, they are here, they have limited leave to remain through the settlement scheme, then they can be absent for up to 6 months in any year without that having any bearing on their potential indefinite leave to remain application in the future. Now, they can in fact be absent for longer than that without losing their limited leave to remain, but they have to bear in mind that the settlement scheme, so the status that they will have been, they should have applied for in the United Kingdom, it's just a one-off. It's just a scheme which is for current European nationals. So if they lose the ability to apply for indefinite leave to remain at the end of that scheme, there won't be another opportunity for them to access the settlement scheme. If they don't yet have their limited leave or their indefinite leave to remain, then I would recommend that they secure that before they leave. Recent events have shown that even with the best intentions to return within a given period of time, it might not be possible to return, and they wouldn't want to be outside the UK and to miss the deadline for applying, because that would put them into some difficulties. So I think for Europeans, in terms of can they? Yes, absolutely. The same provisions apply as all other internationals, but they just need to bear in mind the specific provisions for them and their status in terms of the permitted absences and the impact that those absences will have.
Anything for you on that, Jaspal? No?
No.
Okay, well, from my point of view, if they're EU workers that have been engaged, it sounds like in the UK, and then having more time abroad, then it's back to jurisdiction. I think it's more likely to have jurisdiction than someone working exclusively abroad, because there's a stronger connection to Great Britain. And just as an aside, in terms of what we're talking about the EU, the employment tribunals in the UK are much more likely to assume that there is jurisdiction in the UK jurisdictional the UK, England and Wales employment tribunals, where it's an EU right, and they're more flexible rather than it being a domestic right to find out that should be determined in the UK tribunal system. I think that is probably it. I should probably wrap up there. So thanks for joining us, everyone, and a special thanks to my colleagues Emma and Jaspal for their thoughts and insights today. We will be following up in the next few days. There are a couple of questions we haven't answered, and we'll follow up with those individually with you, and we will send you a copy of the recording today. So thanks very much. Please get in touch should you have any particular questions, but other than that, goodbye.
Bye.